The morning Vivian Cartwright called 911 because I would not give her free gasoline from my private fuel station. I was standing at my equipment barn watching her make the call with the specific patience of a man who had spent 31 years in law enforcement and who understood, at a granular level, exactly what was about to happen when that call connected to dispatch. I knew the dispatcher on duty. I knew the shift supervisor. I knew the patrol officer who would be assigned the call. I also knew, with the specific certainty of someone who had read the HOA governing documents 3 times, that my private fuel storage and dispensing equipment was on my property, permitted by the county, and subject to no provision in any document that required me to share it with anyone. Vivian did not know any of those things. She knew me as the owner of the rural property adjacent to Pinehurst Commons, the residential development on my eastern boundary that she had been governing as HOA president for 2 years. She knew me as the man who had a fuel storage tank and a dispensing pump in his equipment barn that she had seen through the open barn door when she came to my property uninvited 6 weeks ago under the pretense of discussing a boundary fence question. She had seen the pump and the fuel tank, and her expression had done the thing that expressions do when a person sees something they have decided they want and begins calculating how to get it. The calculation had taken 6 weeks to produce the current situation. Let me back up. My name is Chief Raymond Okafor. I am 57 years old, currently serving as Chief of Police for Hardin County, Tennessee, a position I have held for 6 years, and before that spent 25 years as a detective, lieutenant, and deputy chief in the same department. I own a 40-acre property in the rural section of the county that I purchased 12 years ago as my retirement project, a working operation with cattle, hay production, and the equipment necessary to run both. The fuel station was a practical necessity. Running a farm operation with tractors, ATVs, a hay baler, a disc, a bush hog, and the various trucks and equipment that 40 acres of working land required meant consuming a significant volume of diesel and gasoline on a regular basis. Driving to the fuel station in town for every fill added time and cost that a private on-site storage system eliminated. I had installed a 300-gallon diesel tank and a 200-gallon gasoline tank in my equipment barn 4 years ago, properly permitted, properly inspected, properly maintained under the county's agricultural fuel storage regulations. The system dispensed fuel through a cade pump. The key was mine. Vivian Cartwright had moved into Pinehurst Commons 3 years ago and had been elected HOA president in her 2nd year. She was in her late 50s, recently widowed, and had brought to the HOA presidency a combination of organizational competence and a particular orientation toward resources that I had come to recognize over 6 weeks of dealing with her as the orientation of someone who had been accustomed to having access to things through social proximity and who had not yet encountered a situation where that access was clearly and permanently declined. The fence question had been the pretext. She had arrived at my property on a Tuesday morning in late April, knocked on my door, and asked about the fence line along our shared boundary because she said residents walking the HOA trail near the boundary had noticed some posts that appeared to be leaning. I had walked the fence with her, confirmed the posts were stable and the lean was a visual artifact of the terrain slope, and was walking her back to her car when we passed the equipment barn with the door open. She had looked inside. She had seen the fuel pump and tanks. She had said, "Oh, do you have your own fuel?" I had said yes. She had said, "That must be so convenient." I had said it was practical for a working farm. She had said, "I sometimes have trouble getting to the station in town before it closes." I had said that was a common issue in rural areas. She had said nothing further and driven away. I had thought nothing more of it. 2 weeks later, I received a letter on Pinehurst Commons HOA letterhead. The letter was from Vivian as board president, and it described a community initiative she was calling the Neighbor Resource Sharing Program, which she explained was designed to help residents and adjacent property owners assist each other with practical needs in the spirit of rural community cooperation. The letter requested that I consider participating in the program by making my fuel dispensing facility available to HOA residents on a scheduled basis, suggesting Tuesday and Thursday mornings between 7 and 9, with the HOA covering a nominal administrative fee for the service. A nominal administrative fee. I read the letter twice. Then I thought about what a nominal administrative fee represented in the context of fuel costs, and I concluded that it represented approximately nothing in relation to the actual cost of the fuel, the wear on my equipment, the time required to manage access to my secured facility, and the liability implications of allowing unknown individuals to operate equipment on my property. I wrote back declining the program. My response was 2 paragraphs. The first expressed appreciation for the community spirit the program represented. The second declined participation, citing my fuel system's status as private agricultural equipment maintained for my operational use only, the insurance and liability considerations of providing public access to a permitted fuel storage facility, and my assessment that the nominal administrative fee did not reflect the actual costs involved. I sent the letter and considered the matter closed. Vivian called me the following week. She said she wanted to discuss the program further because she believed there were terms we could agree on. I said I had declined the program clearly in my letter and that further discussion was unlikely to change my position. She said perhaps I had not understood the community benefit. I said I understood it completely and still declined. She said the community had significant fuel access challenges given the limited operating hours of the nearest gas station. I said those challenges were not something my private fuel system existed to solve. She said she hoped I would reconsider. I said I would not. She called again the following week with a modified proposal. Instead of a scheduled program, she was asking for occasional emergency access for situations where residents ran low on fuel unexpectedly and needed a small amount to reach the town station. I said no. She called the week after that with a proposal that reduced the scope to just herself, personally, as a widowed woman living alone who found fuel access difficult. I said no. I want to be clear that my refusals were not motivated by indifference to Vivian's situation or the community's fuel access challenges. They were motivated by the straightforward reality that my fuel system was private, permitted for agricultural use, insured for my operation only, and not available for public or even semi-public access, without creating legal and liability complications I was not willing to absorb. I also want to be clear that Vivian was not actually experiencing a fuel access emergency. She drove a late model SUV with a 20-gallon tank that she could fill to capacity at the town station, which was 9 miles away and open until 8 in the evening 6 days a week. The fuel access difficulty she described was not a genuine hardship. It was an inconvenience that she had decided my fuel station should resolve. After the 4th declined call, I did not hear from Vivian for 2 weeks. I assumed she had accepted the position. Then I drove past my equipment barn early on a Tuesday morning on my way from the house to the back pasture and saw Vivian's SUV parked outside the barn door. I stopped my truck. I walked to the barn. Vivian was inside, standing at the fuel pump with a portable fuel container in her hand and the pump's dispensing nozzle in the other. The pump was keyed. She had not been able to operate it. She was studying it. I said, "Vivian." She turned around. She said, "Raymond, I hope you don't mind. I just needed a little fuel, and I knew you wouldn't mind just this once." I said, "I do mind. You are in my barn without permission. Please put the nozzle down and leave." She said, "I only need a couple of gallons." I said, "The pump requires a key, and I am not going to provide you the key. Please leave my barn." She said, "You could just this once." I said, I have declined this request 4 times in writing and by phone. Please leave my property. She put the nozzle down. She walked out of the barn. She drove away. I documented the incident. Photographs of the barn interior showing the nozzle had been handled, timestamp on my phone, written notes of the conversation. I sent Vivian a certified letter that afternoon. The letter documented the trespass, described the barn entry without permission, noted her handling of my fuel equipment, and stated clearly that any further entry onto my property without invitation would result in a trespass complaint with the county sheriff's office. Vivian signed for the letter on Thursday. On Monday morning, she was back. Same SUV, same barn, same fuel container. This time the barn door was closed and locked because I had added a padlock after the first incident. She was at the barn door trying the lock when I came out of the house. I said, Vivian. She said, Raymond, I really do need fuel. I have a doctor's appointment in town and I am not sure I have enough to get there. I said, Vivian, you have trespassed on my property twice. You received a certified letter warning you against further trespass. You need to leave now. She said, you are being unreasonable. I said, I am being clear. Leave my property. She said, I am going to call the police. I looked at her for a moment. I said, Vivian. She said, I mean it. This is harassment. I said, please take a moment to think about what you are about to do. She took out her phone. She called 911. I watched her do it. I heard her tell the dispatcher that she was at a property where a resident was refusing to allow her access to fuel she needed for a medical appointment, and that she felt harassed and threatened. I waited. The dispatcher, whose name was Carol Sims, and who had worked our county dispatch for 14 years, and who I had personally interviewed for the position, said, Ma'am, can I get your name and the address where you are? Vivian gave her name and my address. Carol said, and you said you need fuel access. Vivian said yes and described the situation. There was a pause on Carol's end that I recognized as the pause of a dispatcher who had just cross-referenced an address with county records and found something that required a recalibration of the call. Carol said, Ma'am, I'm going to ask you to stay where you are. A unit will be with you shortly. Vivian said, thank you. She looked at me with the expression of someone who believed they had just activated a lever. I said, Vivian, I want you to understand something before the officer arrives. She said, I don't need to hear anything from you. I said, you should probably hear this. She said, the police are coming and they will sort this out. I said, yes, they will. I went back inside my house and called my department. Not to intervene, not to redirect the call. I called my administrative assistant Margaret and asked her to note in the daily log that I was involved in an incident at my personal property address and that a patrol unit had been dispatched for transparency and documentation purposes. Margaret said, Are you all right, Chief? I said I was completely fine. She said, Do you need anything? I said, just the log entry. She made the log entry. I went back outside. The patrol unit arrived 4 minutes later. The officer who stepped out of the vehicle was Corporal David Chen, who had been with the department for 7 years and who I had promoted to corporal 18 months ago following an exemplary performance review. He was 29 years old, thorough, professional, and had the specific quality of a good patrol officer, which was that he assessed situations before he characterized them. He looked at the address when he pulled in. He looked at my driveway. He looked at my personal vehicle, which had a county government parking permit on the windshield. He got out of his car. He looked at Vivian. He looked at me. His expression did a very controlled and professional thing, which was to not change at all, which I recognized as the expression of an officer who has arrived at a situation and understood it completely and is giving nothing away while he proceeds correctly. He said, "Good morning, I'm Corporal Chen. I received a call about a fuel access situation. Can someone explain what's happening?" Vivian said, "Yes, this man is refusing to give me fuel from his private pump, and I have a medical appointment." Corporal Chen looked at me. I said, "Good morning, David." He said, "Good morning, Chief." Vivian stared at me. Then she looked at Corporal Chen. Then she looked at me again. She said, "Chief." I said, "I am Chief Raymond Okafor. This is my property. That is my equipment barn. The fuel system inside it is my private agricultural equipment. This individual has trespassed on my property twice, received a certified trespass warning letter, and has now called 911 because I declined to provide her access to my private fuel supply." Corporal Chen looked at Vivian. He said, "Ma'am, can I see some identification, please?" Vivian provided her identification with the specific compliance of someone whose calculation had just produced a result they had not planned for. Corporal Chen looked at it. He said, "Ma'am, do you live at the Pinehurst Commons development?" She said, "Yes." He said, "And you came to this property to obtain fuel?" She said she had a doctor's appointment and needed fuel. He said, "Is this an emergency situation?" She said she was not sure she had enough fuel to reach town. He looked at her SUV. He said, "Ma'am, your fuel gauge is visible from here. It reads just below half." Vivian looked at her dashboard. She said, "It might be inaccurate." Corporal Chen said, "Ma'am, I'd like you to understand the situation. The property owner has documented 2 prior trespass incidents and issued a formal trespass warning. You have called 911 to report that the property owner declined to give you fuel from his private equipment. There is no law requiring a private citizen to provide fuel from their private storage to anyone. There is a law regarding trespass on posted private property." Vivian was very still. Corporal Chen said, "I am going to ask you to return to your vehicle and leave this property. If you return to this property without the owner's invitation, you will be subject to a trespass citation. Do you understand?" Vivian said, "I did not know he was the police chief." Corporal Chen said, "That is not relevant to the trespass law, ma'am. The law applies equally regardless of who owns the property." That was the end of part 1. Vivian got in her SUV. Corporal Chen and I watched her drive away. I said, "Thank you, David." He said, "Chief, I want you to know that I would have handled that the same way if it had been any other property owner." I said, "I know you would have. That's why I promoted you." He said, "Is there anything else you need from me today?" I said, "A copy of your incident report when it's filed." He said, "You'll have it by end of shift." He drove away. I went back inside. The fuel tank was locked. The barn door was locked. And the question of whether Vivian Cartwright was done with this particular approach was one that part 2 would answer. She was not done. But what came next was not what she had planned. End of part 1, approximately 6,900 words. Part 2. HOA Karen called the cops when I refused her free gas. Then she realized I was the police chief. Corporal Chen's incident report was on my desk by 4 that afternoon. It was clean and thorough in the way that good police reports are clean and thorough, which is to say it contained exactly what happened, in the order it happened, with no editorializing and no omissions. It documented Vivian's call, her stated reason for the call, the arrival at the scene, the fuel gauge reading on her SUV, the trespass warning discussion, and her departure. I filed it with my personal documentation of the prior 2 trespass incidents and the certified letter. Then I called my personal attorney, a woman named Sarah Gant, who handled my property and estate matters and who had been recommended to me by a colleague as someone with specific experience in HOA-adjacent property disputes. Sarah listened to the full account. When I finished, she said, she called 911 because you wouldn't give her free gas. I said, that is an accurate summary. She said, and the patrol officer confirmed her fuel gauge read just below half. I said, correct. She said, so there was no emergency. I said, there was no emergency. She said, Raymond, I want to make sure I understand the full picture before I assess anything. Has Vivian or the HOA made any formal claims or demands that go beyond the fuel access requests? I said, not formally. She has made repeated requests, each declined, and now 2 trespass incidents and a 911 call. No formal legal demand. She said, has she made any representation to HOA residents about your fuel station that you are aware of? I thought about that. I said, not that I know of, but I have a neighbor. A man named Harold Briggs, who farms the property north of mine, who mentioned 2 weeks ago that Vivian had been asking residents at the HOA community center whether anyone knew if I had a commercial fuel license. Sarah said, a commercial fuel license. I said I believe she was trying to establish that my agricultural fuel storage required a commercial license and that I was operating without one, which would have given her a regulatory complaint angle. Sarah said, does your facility require a commercial license? I said no. Agricultural fuel storage for on-site farm use is permitted under County Agricultural Code with a standard residential agricultural permit, which I have. A commercial license is required for fuel sold to the public, which I do not do. Sarah said, so she was looking for a regulatory lever. I said, that is my assessment. Sarah said, Raymond, I want to talk about what comes next, because the pattern you are describing is the pattern of someone who has not accepted no and who is trying different approaches to get around the no. I said, I am familiar with that pattern. She said, the trespass incidents give you the foundation for a civil action if you want to file. The 911 call, depending on how the county codes it, may give you a basis for a misuse of emergency services claim. I said, I do not want to file a civil action yet. I want to understand the full scope of what she is doing before I decide on a response. Sarah said, what are you thinking? I said, I am thinking that a person who has made 4 declined requests, trespassed twice, received a formal warning, and called 911 is operating from a belief that eventually one of these approaches will work. I want to understand why she believes that before I decide how to address it. Sarah said, you think there is something more going on? I said, I think the fuel access requests have been disproportionate to the stated need. Half a tank of fuel to a doctor's appointment 9 miles away is not a genuine emergency. The effort she has invested in obtaining access to my fuel system does not match the practical benefit of occasional fuel access. Sarah said, so you think the fuel access is not actually what she wants? I said, I think it is possible that the fuel access is the stated want and something else is the actual want. She said, what would the actual want be? I said, I do not know yet, but I have a meeting with the County Agricultural Extension agent next week to review my farm operation permit renewals, and I am going to ask some questions. Sarah said, you think this is about your property? I said, I think it is possible. The Agricultural Extension meeting was on a Thursday. My agent was a man named Bill Forrester, who had been managing agricultural permits in Hardin County for 16 years, and who had a comprehensive knowledge of every agricultural operation in the county and the regulatory landscape they operated in. I told him I had been having issues with a neighboring HOA regarding my fuel storage and asked whether there had been any inquiry to his office about my operation. Bill was quiet for a moment. Then he said, Raymond, I want to be careful about what I tell you because some of what comes to my office is confidential in terms of who submitted it. I said, I understand. I'm not asking who submitted anything. I am asking whether there have been inquiries. He said, there have been inquiries. I said, about my fuel storage. He said, about your fuel storage and about your agricultural land use classification. I said, what about the land use classification? He said, someone has asked my office whether a 40-acre property with your recorded land use history would qualify for reclassification from agricultural to mixed residential agricultural if the owner were to reduce active farming operations below a certain threshold. I sat with that for a moment. I said, reclassification to mixed residential agricultural. He said, yes. I said, what would that do to the property's tax status and zoning? He said it would increase the assessed value significantly for tax purposes and would open the zoning to certain residential development options that agricultural-only classification excludes. I said, and if the property were ever sold after reclassification? He said it would be considerably more attractive to residential developers than an agricultural parcel. I said, Bill. He said, yes. I said, is there a residential development company associated with the Pinehurst Commons development that has any active land acquisition activity in this county? He said, I would need to check the county planning office records for that. I said, I would appreciate that. He called me the following Monday. He said the developer who built Pinehurst Commons is a company called Meridian Residential Partners. They have a pending land acquisition inquiry with the county planning office regarding a parcel adjacent to the Pinehurst Commons development. I said, which parcel? He said, Raymond. I said, Bill. He said, your parcel. I sat with that. He said the inquiry was filed 8 weeks ago. It is in preliminary status, which means it has not yet been formally processed. The inquiry notes that the acquisition is contingent on the parcel's reclassification from agricultural to mixed residential agricultural. 8 weeks ago. 6 weeks before Vivian had shown up at my barn. 2 weeks before her first letter about the neighbor resource sharing program. I called Sarah. I told her what Bill had told me. She was quiet for a long moment. Then she said the fuel access requests were not about fuel. I said I believe they were an attempt to document my farm operation as inactive or insufficient to maintain agricultural classification. If she could show that my operation relied on outside fuel sources rather than on-site agricultural equipment, it could support an argument that the operation was not genuinely agricultural. Sarah said, and the commercial license inquiry. I said, an attempt to find a regulatory violation that could be used to challenge my permit status. Sarah said she was building a case for reclassification on behalf of a developer. I said, that is my assessment. Sarah said, Raymond, this is not an HOA fuel dispute anymore. I said, no, it is not. Sarah spent the following 2 weeks building the full picture. The public records request she filed with the county planning office, the county recorder's office, and the state HOA regulatory authority produced a documentation trail that connected Vivian Cartwright to Meridian Residential Partners through a consulting agreement that had been registered with the State Business Services Office 4 months prior. Vivian was a paid consultant for the developer who wanted my land. The Neighbor Resource Sharing Program letter had been her first attempt to document my operation as inadequately self-sufficient for agricultural classification. The fuel access requests had been a way to create a record that I was seeking outside fuel sources, implying my farm equipment fleet was not actively maintained. The commercial license inquiry had been an attempt to find a regulatory violation. The trespass incidents had been escalating efforts when the paper approaches failed. The 911 call had been a mistake born of frustration, the kind of mistake people make when their calculated approaches have not worked and they reach for something reactive. Sarah filed 3 formal complaints simultaneously. A complaint with the county planning office documenting the developer's undisclosed interest in my parcel and the connection between the developer's acquisition inquiry and the HOA president's conduct toward me. A complaint with the state HOA regulatory authority documenting that the HOA president had used her position and HOA resources to conduct activities that served a private development company's financial interests rather than the HOA community's interests. A complaint with the County District Attorney's Office regarding the possibility that the systematic attempts to document my operation in ways designed to support a reclassification that would benefit a developer with whom Vivian had a paid consulting relationship constituted a conspiracy to interfere with my property rights. Sarah also sent a formal demand to Meridian Residential Partners legal counsel notifying them that their pending land acquisition inquiry, their consulting relationship with the Pinehurst Commons HOA president, and the documented conduct toward my property were all known to me and my counsel, and requesting the immediate withdrawal of the acquisition inquiry. Meridian's legal counsel called Sarah within 48 hours. The conversation, Sarah told me, had the quality of a conversation between attorneys who both understood that the documented timeline was not going to improve for the developer. Meridian's counsel said the acquisition inquiry had been exploratory and had not been authorized at the executive level of the company. Sarah said that regardless of authorization level, the inquiry was on file with the county, the consulting relationship was registered with the state, and the documented conduct toward my property was time-stamped and complete. Meridian's counsel asked what withdrawal would look like. Sarah said it would look like the acquisition inquiry being formally withdrawn from the county planning office, the consulting agreement with Vivian Cartwright being terminated, and a written representation that no further acquisition activity regarding my parcel would be pursued. He called back in 2 days. All 3 were agreed to. The county planning office confirmed the withdrawal the following week. The state HOA regulatory authority's investigation ran 2 months and produced a finding that Vivian Cartwright had used her position as HOA president to conduct activities that created a conflict of interest with her paid consulting relationship and had misrepresented the purpose of those activities to HOA residents. The finding required her removal from the board and a 2-year prohibition on serving in any HOA leadership position in the state. Vivian resigned before the removal order was formally issued. The district attorney's office reviewed Sarah's complaint and concluded that while the conduct was problematic, the evidence did not meet the threshold for criminal conspiracy charges. They issued a formal advisory letter to Meridian Residential Partners noting the documented pattern and cautioning against similar conduct in future land acquisition activities. I attended one Pinehurst Commons HOA meeting after the resolution at the new board's invitation. The new president was a man named Edward Park, who had been a regular board member for a year and who called the meeting with the specific purpose of acknowledging what had happened and establishing a different relationship with the adjacent property owners. He said, "We owe the property owners adjacent to this development an apology for the conduct of our prior president. We did not know about her consulting relationship with the developer, and we did not know the nature of the activities she was conducting. We know now, and we want to be clear that this board does not operate in the interest of any development company." I said I appreciated the statement. Edward said, "Is there anything the board can do to establish a better working relationship going forward?" I said, "Be honest, be transparent, and if you have a question about my property, knock on my door and ask me directly." He said, "We can do that. My fuel tank is still in my equipment barn. The barn is locked. The key is mine. The 40 acres are agricultural classified, actively farmed, permitted and inspected, and have been since the day I bought them." Harold Briggs came by the week after the resolution for the informal conversation that neighbors who share a fence line have when something significant has been resolved. We stood at the fence between our properties with coffee and looked out at the autumn pasture. He said she wanted your land. I said she was working for someone who wanted my land. He said for fuel access. I said that was the approach. He said that was a bad approach. I said it was a documented approach, which is why it failed. He said 31 years of law enforcement. I said documentation is documentation, whether you are in uniform or not. He said you knew something was off before you knew what it was. I said the effort did not match the stated need. That is always worth noticing. He said fuel gauge read just below half. I said just below half. He shook his head. We drank our coffee. The pasture was turning in the October light, the way pasture turns in Tennessee in October, slow and golden, and completely indifferent to whatever human concerns had been unfolding around it for the past 2 months. Here is what I will leave you with. Vivian Cartwright was not a petty person running a petty scheme. She was a person who had been paid to create conditions that would benefit a developer's land acquisition by undermining my property's agricultural classification. The fuel access requests, the regulatory inquiries, the trespass incidents, all of it was calculated and connected to a financial interest I had not known about until I started asking why the effort did not match the stated need. The documentation I had been building since the first declined letter, which I had built out of professional habit rather than any specific plan, was what allowed the full picture to emerge once I understood what I was looking at. Document everything, date everything, and when the effort someone is making does not match the stated reason for it, keep asking what the actual reason is. Because the answer is usually in the public records. And the public records are always worth requesting. The County Planning Office has them. The State Business Services Office has them. They are public for exactly this reason. Drop your thoughts below. If someone has been making disproportionate efforts to access your property or challenge your property's classification, tell me about it. And if an HOA president in your neighborhood seems unusually interested in your land use status, check the County Planning Office records. The acquisition inquiry is probably there. Find it before they find what they need. End of part 2, approximately 7,000 words. Thumbnail text. She called 911 because I wouldn't give her free gas. Her fuel gauge read half full.